Well, hello everyone, and welcome to One Civil Law, and happy Friday night. I hope everyone is having a very good day today, and we want to do a little Friday night hangout for all those of you who are jonesing for that Friday night legal experience. In the absence of Law and Lumber, I will be Discount Law and Lumber. Not as good, but we do what we can in these trying times. We all have to make do. And speaking of making do, we begin with today's story, wherein the search for eggs becomes just a little bit more real as police are searching for a person who stole $100,000 or 100,000 eggs from a distribution truck. Wow. I mean, I heard eggs were expensive, but we're stealing and fencing eggs now. We're fencing eggs. Probable culprit, a chicken. Chicken no fences, right? Probably. We stole 100,000 eggs from a distribution truck. Wow. Wow. It is the new yellow gold. Or maybe it's the white gold. Or maybe it just depends. Okay. 100,000 eggs. Let's read this story. The heist of 100,000 eggs from the back of a trailer in Pennsylvania has become a whodunit. It wasn't me. 4 days after the theft, law enforcement said it could be tied to the sky-high cost of eggs. Probably. No leads have come in. Trooper First Class Megan Frazier, a spokesperson for the Pennsylvania State Police, said on Wednesday, saying, quote, "We're relying on leads from people from the community. So we're hoping that someone knows something and they'll call us and give us some tips." Well, we would put the wanted on the back of an egg carton, but we can't because they stole the eggs. Damn it. Police are following up with any possible witnesses and looking into surveillance footage that could help them identify the perpetrator. In my career, I've never seen 100,000 eggs be stolen. You don't say, Trooper. Really? Wow. You're telling me that you've never worked a case before where 100,000 eggs are stolen? You've never seen that one? This is a first? If it wasn't a first, I'd have further follow-up questions. So, I'm not particularly surprised it's a first. We're stealing the eggs now. This is definitely unique, said Frazier. Bird flu is forcing farmers to slaughter millions of chickens this month, pushing egg prices to more than double their cost of 2023. And it appears there's no relief in sight with Easter approaching. Maybe we just really, really want to do that egg hunt for Easter. I'm not sure how we're going to preserve the eggs for that long, but I'm sure it can be done. Where there's a will, there's a way. We must have the eggs for Easter. Okay. The average price per dozens of eggs nationwide hit $4.15 in December. That's not quite as high as the $4.82 record set 2 years ago, but agriculture predicts egg prices are going to soar 20% this year. If this works, if this winds up being an arbitrage thing, that will be amazing, right? It's a price speculation bubble that has resulted in eggs being stolen. We are forecasting the eggs being stolen. And so we are taking the eggs with the fact that we're going to cash in when the cows come home, except this time, again, probably chickens come home. When the chickens come to roost is when we're going to make our egg-related profit. Fantastic. That's great. The 100,000 eggs were snatched from the back of Pete and Jerry's Organics distribution trailer. Maybe Pete and Jerry are in on it. Unclear. About 8:40 p.m. in Antrim Township, according to police. They are worth about $40,000, which means the crime is a felony. This is like the worst felony ever. Or maybe it's the best felony ever. I don't know. How do you think that would work out in prison? How do you think that would work out when people are like, what are you in for? I stole a car. I stole a painting. I stole 100,000 eggs. Do you think that gets you cred in prison or not? How does egg theft work in the prison hierarchy? Questions I did not know I needed the answers to. Questions I did not know I needed the answer to. Maybe they're like the mafia's eggs, though. He'll find out that was the mafia's truck, and he hijacked the wrong truck. Who can say? Yeah. Pete and Jerry's Organics LLC said the company is working with law enforcement to investigate the theft. We take this matter seriously, and we're committing to resolve it as quickly as possible, the company said. Well, that's an exciting story for sure. That's an exciting story of egg theft. I can only hope that the bandits plan this one out and have somewhere to refrigerate the 100,000 eggs. Do you think that they just open up a roadside stand? That'd be a little suspicious. I mean, I've heard of people selling eggs on the roadside before, like from farms and stuff. But I don't know, man. How do you sell 100,000 eggs? They've got to be priced to move. How does that work? Who do you sell them to? Do you pretend they're farm fresh eggs? Do you try to fake their origin to jack up the price? Say they're organic? Who knows? All kinds of stupid. It's a fun story for sure. All right, let's read a little bit more about another stupid of a different variety. Attorneys behaving badly in today's news. Okay, attorneys, here are some pro tips about what not to do. Now, there is a rule. I believe it's rule 8. I believe it's rule 1.8K, if memory serves correctly, that basically says lawyers shouldn't sleep with the client. Now, this lawyer took it another step forward. I don't think rule 1.8 specifically contemplated this possibility. Maybe the bar needs to update its ethics manual. This attorney didn't so much sleep with the client as force the client into prostitution. Yeah, that's a problem. You shouldn't force the client into prostitution. I didn't know we needed an ethics rule for that, but in case we do, don't force the client to become a prostitute. Good tip. He also hired people to kill a former client. This attorney does not understand the assignment. This attorney does not understand the assignment. You're not supposed to force the client into prostitution, and you're not supposed to hire a hitman to kill the client. Neither of these things are in the rules of ethics. It's been a while since I've read the rules of ethics, but I'm pretty sure neither of these things are contemplated as being, within the scope of representation. Maybe don't do these things. Just saying. The Las Vegas defense attorney, because of course he's Las Vegas. The Las Vegas defense attorney is accused of forcing clients into prostitution and apparently referring to himself as a gorilla pimp. Also, pro tip, do not refer to yourself as a pimp or gorilla pimp. It's not really helpful with your legal defenses. I'm not sure what the difference between a pimp and a gorilla pimp is. Unclear if he also pimps gorillas. Not sure about that one. But either way, probably not going to hurt his claim. I help his claims. Probably not going to work out for him. In the 50-page arrest report, the Las Vegas Metropolitan Police Department detailed what landed the 62-year-old criminal defense attorney, Gary Guyman, behind bars. Double G, baby. Double G pimp style. Las Vegas police say they started investigating Guyman in November 2024 after receiving information that he was inducing and encouraging prostitution from women to do sexual acts to him and people he knew. That's not good. Detectives say Guyman was the attorney for 4 women listed as victims in the arrest report. 2 of those victims had prior prostitution charges. Yet you can't sleep with the client, even if it's like for like services. I'm sorry. No. The attorneys can get paid and anything legal, but even in Nevada, you can't exchange services for services if the client is a prostitute. Even if they're a legal prostitute, you can't sleep with the client. Okay? Or maybe you can. I have honestly not looked at Nevada's rules. If they have a specific exemption in their rules or in the interpretation of their rules that contemplates legal prostitution with the clients, then, you know, I guess shame on me for not knowing that exemption. But I'm just going to go on the presumption there's no such exemption in the law, although, you know, it's Nevada, so who knows? Maybe it's okay in Nevada, as long as it's prostitution. You can't sleep with the client normally, but if it's prostitution, maybe it's suddenly okay again. I don't know how that, I honestly don't know how that works. I don't know how that works. Detectives believe Guyman ran a sex trafficking ring nicknamed the $100 Club. I have follow-up questions. I don't know what the going rate for a prostitute is, but $100 sounds a little low for these kinds of services. Where are we getting these prostitutes? What kind of prostitutes are they? $100 prostitutes. It feels a little below market value. Maybe he deals in quantity. That's the secret. He deals in quantity and he brings the savings to you. Feels a little low. Feels a little low. Yeah. Especially with inflation, Jules. Even $100 an hour doesn't necessarily sound right. Again, I'm not an expert on these prices, but, you know, you would think, you know, that you'd be able to command a little bit more value, but, you know, $100 an hour, man, I don't know, man. It seems, yeah, that doesn't seem right. Police say that one of Guyman's former clients told investigators she first met him last July. He agreed to be her lawyer for district court and a family court case. She said their attorney-client relationship turned romantic a month later. Don't sleep with the client. But began to sour in October. The woman claimed he bought her a car and leased an apartment for her. The bar is going to have questions, man. The police report detailed explicit text messages Guyman sent to her, including that he would be her gorilla pimp for the next year. He put it in a text message. The attorney put it into a text message. Okay, legal pro tip. Do not tell your would-be prostitute that you're willing to be their gorilla pimp in a text message. And if she were to resist, he would smash her teeth. Also, probably shouldn't put that in a text message. Probably shouldn't say, if you don't prostitute yourself, I will break your teeth. You know, that could technically qualify as rape, depending on the jurisdiction. I mean, you'd have to actually go into the definitions to see, but you're now, it also could qualify as human trafficking because you're now forcing someone to engage in sexual behavior. So, and it also qualifies as extortion, and it also qualifies as larceny. So at this point, I'm just counting. So let me see what I got. I got facilitation of prostitution. I got conspiracy to commit prostitution. I've got larceny. I've got extortion. I've got rape, and I've got human trafficking. That's what I've got off the top of my head as possible crimes. I'm sure I could think of some other stuff if I really thought about it. Is he possibly transporting the people across state lines? Then it's a violation of the Mann Act. It's like, where do you want me to start? Stop. It's just with counting stuff. It's not going great, guys. It's not going great. Police say in the report that a gorilla pimp, apparently this is a term of art. I apologize. The police are now going to tell me that gorilla pimp is apparently a term of art in the community. I'm sorry. I just thought it was a random description. I apologize. Apparently gorilla pimp is a term of art among pimps, I guess. It's a specific known type of pimp. I'm just ignorant of it. Well, I feel like an idiot that I didn't know that gorilla pimp was a specific thing and a designated thing. I feel like a stupid. I'm sorry. Gorilla pimp apparently is a term for a pimp who's physically violent towards prostitutes. Okay. Detectives say they believe Guyman used threats over her family court case, the car, and the apartment to control her. Yeah, the threats relating to your case are not going to sit well with the bar. The bar is going to have some questions relating to several of these things. The bar is going to have several exciting follow-up questions. Apparently, he said in a text message again, guys, don't text your crimes. He said in a text message, do not call me your life coach. Call me your MFing pimp. Guyman allegedly texted, offer any resistance and I might just smash your effing teeth out of your mouth. Don't worry. My father or brother will fix them when I have them get around to it, and I'll pay for that too. Biatch. Wow. Yeah, it's not going great, guys. It's not going great. The police report said that one of Guyman's associate offered to pay the former client's rent if she agreed to stop cooperating with the investigators into Guyman. Oh, that's nice. One of your associates is offering to pay if you stop cooperating. Oh, okay. So let me see. That's obstruction. That's interference with a witness. Yeah, that's good news. And of course, it's conspiracy. It's conspiracy. Can't forget conspiracy. The guy is a one-man Rico. The guy is a one-man Rico at this point. It's going, yeah. Detectives began wiretapping Guyman's phone on January 7th, according to the report. A few days later, police listened to a call between Guyman and his alleged mistress. He said on the phone, apparently, quote, as they tapped the phone, he said on the phone, quote, it doesn't end with her. I'm not saying I'll have anything to do with this, but the only way to stop this girl is to kill her. I'm not saying that's the solution, Guyman said. The next day, police listened to a call between Guyman and his associate. Guyman spoke vaguely about paying another person when it's done. Oh. Yeah, there's that conspiracy murder for hire. Oh. It's conspiracy murder for hire. Oh, okay. Yeah. Where do the charges stop, guys? When do I get to stop counting? Detectives talked to another report victim who hired Guyman to defend her in a prostitution case. Police say Guyman coerced her to perform sex acts on his boat or she'd go to jail. Again, potentially, it's extortion. It's potentially rape. It's larceny. It's a whole lot of things. Yeah. After police interviewed her, Guyman called her, saying he'd pay her $1,000 to lie. Oh, there's that obstruction, interference with a witness again. In November 2024 interview with police, Guyman denied being in a romantic relationship with his former client. He sent detectives more than 40 emails, messages, and voicemails explaining his relationship with his former clients. This guy's not necessarily the greatest attorney, I have to say. He himself sent detectives 40 emails, messages, and voicemails. This guy is not the greatest attorney, guys. I'm thinking maybe you shouldn't hire him. I'm thinking he's not very good. Maybe don't hire that guy. Tony says kidnapping in chat. Maybe. Depending on the details, possible. Police say they interviewed Guyman again on January. He said his interactions with former clients were consensual. He also admitted to introducing those clients to his associates. Introducing. Guyman was arrested on Monday. The arrest report says he agreed to speak with police. And denied hiring anyone to kill one of his former associates, but said he may have had conversations with people to speak to her. Court records show Guyman posted bail on Monday and a court appearance was canceled. Guyman is facing charges that, for the moment, include sex trafficking, bribing or intimidating a witness, and conspiracy to commit murder. Court records show that 2 judges so far have recused themselves from the case because of a conflict. None of the other people named in the arrest report are facing charges to the case relating to this time. Yeah, he's going to have a bad day. He's going to have a very, very bad day. They'll find a judge eventually, or they'll import one from another county. He's going to have a bad day. All right. For our next story, we're going to watch another stupid attorney. Now, I don't know much about this story, except what the title of the video is, and it was provided by my mod Kestrel. The video is entitled Karen Lawyer Can't Handle Herself in Traffic Court and She's Running for Judge. So apparently this is a lawyer and would-be judge who things did not go well in traffic court for. And we're going to watch their appearance in traffic court, and we will comment on their knowledge of the law and other things as may be relevant that we need to comment on. So we'll go ahead and do that. So let's go ahead and get started with this. This will be fun. All right, what you got?
How is anything that you've told me so far going to explain whether or not you left the roadway or not?
Because it tells you how it happened. I was being careful.
No, it doesn't, Pam. The fact that you were in an accident in the past on a different road has no bearing on what's happening here.
It does, because I was rear-ended and slammed into the vehicle in front of me, and it caused me trauma.
Okay.
Early. Miss Canfield-Cadbury, you can hear me, right?
Yes, I can.
All right. This is a citation that was issued on January 10th of this year on US 131 there in Wayland Township. Said too fast for conditions involving an accident. You're hearing me? I'm on this citation to do
that's her. That was her ad. I was wondering why I put up. This is apparently her ad. I'm sorry. I was wondering why this came up. Angelique Canfield for judge. We need a judge with extensive courtroom experience. Okay. Let's see how you're doing, Angelique. Let's see how you're doing with your extensive courtroom experience.
You're hearing me? I'm on this citation to do one of 3 things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight this ticket at what we call informal hearing. What were you looking to do?
I want the hearing, please. I deny responsibility.
All right. Then the first thing I do is swear you both in. You want to go ahead and raise your right hands. You swear or affirm any testimony that you give here today would be the truth, the whole truth, and nothing but the truth.
Yes.
Yes, sir.
All right. Ma'am, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place, but then after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Yes, can I just state something for the record?
We're already off to a bad start, right? The prosecution has the burden of proof and she wants to make a statement for the record. Oh, Lord.
First, before we begin.
Sure.
The only thing that I wanted to state is that I did previously request an adjournment of this because I did suffer a head injury and I am written off from work because of my head injury by a concussion doctor at the neurology center at Bronson. I'm not supposed to be practicing law, so I don't feel that I should have to go forward. But I was told by the court we could not adjourn this unless I wanted to have a formal hearing and skip this process. So I just—
That is correct.
I
If
wanted—
you don't want to go forward today, you can ask for formal hearing. That'll get reset and they'd be compliant with you asking for a date considerably farther out. But for informal hearing, we don't move dates, either by officer or by defendant.
Yeah, I just wanted the court to be aware that my processing right now is slower. And so I might take—
So it sounds like if you want a formal hearing, you can ask for it. If I just understood what the judge just said, right? It's like, well, if you want a formal hearing, we can do that. But if you want an informal hearing, then no. And so like the thing to say is, I want a formal hearing. And then you would get it, right? That's what I just understood. Because it's your choice. Well, okay. So.
take a moment to ask questions and things.
That's fine. We have time.
Thank you.
All right. And so with that, Deputy, you want to pick up the narrative somewhere where it makes sense and explain the issuing of this citation?
Yes, sir. So on January 10th, 2025, shortly after 5:04 p.m., we were dispatched to southbound US 131, just south of the 6-1 mile marker on ramp, for one vehicle crashed into the ditch. Upon arriving on scene, we found a single vehicle identified as a 2016 Chevy, red in color, with the attached Michigan license plate of Edward Lincoln David 430, into the right-hand shoulder of southbound US 131. Through investigation, I found that the vehicle was traveling southbound when it had lost control, went into the ditch, and did sustain damage. I did issue the driver and the only occupant of the vehicle identified as Angelique, and I don't know if I'm pronouncing that right. Angelique Camfield Kuiper, the citation for the violation of the basic speed law for driving too fast. I did issue her citation SD 33604.
All right. And Ms. Camfield Kuiper, what is it you wish to tell me?
I would like to cross-examine the deputy, please.
Okay.
And Deputy Earl, how long have you been a deputy for the Allegan County Sheriff's Department?
I've been here for 2.5 years.
Any prior law enforcement experience?
Yes, ma'am. I've been an officer prior to that for a separate agency for a year and a half.
When did you graduate the academy?
I believe it was 2020.
And what—
Ms. Camfield Kuiper, how would this be relevant to your citation?
I think I have the right to ask him his background and experience to determine whether I was going too fast when there was no
Ma'am,
personal observation.
Then let me just put something on record here. This is not a speeding ticket. It's not accusing you of speeding. You can get this ticket going 10 miles an hour. What it is you have a duty to maintain your vehicle on the roadway. Weather conditions and road conditions are not a legal defense to this ticket. Essentially, the only legal defense to this ticket is I didn't slide off the road. So I'll let you proceed, but what the officer's experience is not relevant. He's not making a judgment call that you were too fast for conditions. He's simply observing that your car left the roadway. That is the only element to this citation.
Actually, Your Honor, I looked up the statute, and the statute says exactly, it is under the speeding statute under 257 627 parents 1 that I,
Yes, ma'am, but like I said, if you're going 10 miles an hour and you slide off the roadway, you will still get this citation. It is not accusing you of speeding. It is accusing you of going too fast for conditions. The prima facie evidence of that is that you left the roadway. But
Well,
you can
I
continue.
respectfully disagree with the court on that. Deputy, did you personally observe any of my driving that day?
No,
Did you speak to anybody who personally observed my driving that day?
no, ma'am.
Can you tell me what the weather conditions were that day?
I believe they were cloudy with snow.
Can you tell me where you were when you were dispatched to the scene?
I believe I was in Wayland when I was dispatched to this scene.
Do you know what the distance was that you were away from where my car was?
I do not.
Do you know how long it took you to get there?
I do not.
Do you know if the snow began earlier in the morning and was accumulating on the highway?
I do not recall.
Do you know if it was icy in addition to being snowy that day?
I do not recall.
Did you have an opportunity to review your accident report prior to testifying today?
Yes, ma'am.
Do you recall on your accident report that you wrote there was no ambulance at the scene?
I do not recall.
Would you refresh your recollection if you saw your accident report?
Yes, ma'am.
Do you have that with you, sir?
Yes, I can pull it out.
Could you take a look at that, please, and tell me whether you marked an ambulance was present or not?
Ma'am, can you tell me whether or not it would be relevant whether or not there was an ambulance there?
Yes, Your Honor. If the deputy can't recall what the weather was, how long it took him to get there, whether it was icy in addition to snowing, and there are errors in the traffic report, it calls into question the veracity in his recollection with respect to that day.
Fair point.
Okay, but ma'am, the relevant sentence would be your testimony. Whether, are you denying that you had an accident and left the roadway?
No, Your Honor, but I have
That's
other.
the only pertinent question.
Well, the right answer to that question, incidentally, was that was the wrong answer. The right answer to that question is, Your Honor, I've denied my responsibility. Was the correct answer. The correct answer to that question is, Your Honor, I have pled not guilty and I deny every element of the crime. That was the right answer to that question. Not, no, I'm not denying it. In which case, yeah, that was the wrong answer. And she has every right to deny every element of the crime. She has every right to deny it. That's what a not guilty plea is. Make the state prove it. And so, like, yeah, I deny I had an accident. That works. I chose to park in the ditch because I like ditches. Prove I didn't, you know? Yeah.
I have other information to present to the court.
Okay, why don't we present it in the form of testimony as opposed to cross-examination, and I'll determine whether or not this line of inquiry is relevant to a civil infraction, ma'am.
Okay.
See, again, I would respectfully suggest that was the wrong answer. You say, Your Honor, with respect, I'm not compelled to give testimony, and I'd like to continue my cross-examination. That was the right answer to that question, which she should know.
I guess I don't.
Or hire a lawyer to do it for you if you're not
Okay,
feeling
let
it.
me put it another way. Road conditions and weather conditions are not a legal defense to this ticket. You have a ticket that says your car left the roadway. Do you have any information to present that your car didn't leave the roadway?
No, the ticket, the statutory section.
Well, to be honest, that's a misstatement of the law by Your Honor. So that is a misstatement of the law. The statement isn't, the charge is not that she left the roadway. The charge is that she was driving too fast for conditions. Those are not the same thing. So again, like if she were more on her game, she'd say, Your Honor, with respect, I'm not charged with leaving the roadway. I'm charged with driving too fast for conditions. And so the mere fact I left the roadway does not prove that I was driving too fast, because I chose to leave the driveway. I chose to leave the roadway because I like ditches. Ditches are my friend, right? Right. So that's the wrong answer. And the judge made him a statement of law, and you should correct him.
And says, did I operate at a careful and prudent speed, not greater than nor less than what's reasonable and proper, having due regard to the traffic, surface, width of the highway, and any other condition existing.
I'm infinitely familiar with the statute. Here's the issue. The testimony is that your car left the roadway. That is the prima facie evidence that you were not traveling at a speed conducive to the weather conditions and the road conditions. Ma'am, you can make that argument, but what I need to hear before I make a ruling, is we're getting way far afield of the information I need, is whether or not your car, you had an accident where you left the roadway that day. I have a testimony that you did. If you would like to provide testimony that that didn't happen, that would be relevant for this citation.
So none of the road or weather conditions are relevant to this action?
No, ma'am. I sit here all winter, every year, getting this citation. If you have a slide.
I tend to agree with, my superficial understanding is I tend to agree with her reading. Like, because go back to what the statute said, right? It's always a good thing to remind yourself what the statute said. So listen more carefully to what he said, right? Or what she said. Let's assume she's reading the statute correctly. Let's give her that much.
I have a testimony, ma'am, you at the road was
reasonable. The statutory section says, did I operate at a careful and prudent speed, not greater than nor less than what's reasonable and proper?
Yeah, so was I operating at a prudent speed, not less than or greater than what's reasonable and proper, right? So
having due regard to the traffic.
Having due regard for the conditions. So that I disagree with his Honor's reading of the statute, right? Because if it was not apparent to me that the road was foul, then I can operate in due regard to my perception of the road. And if the road was suddenly slick or suddenly snowy or black ice or something, right, and that was not readily apparent, then I might be very well operating in due regard. So I disagree based on her based on the way she reads the statute. I think her reading makes more sense to me.
Width of the highway. And any other condition existing.
I'm infinitely
with any other conditions that existed at the time. So I disagree with his Honor's reading based on the statute. It's like all I have to do is drive with due regard in neither too fast nor too slow, as reasonable, based on the conditions that were apparent. And so if they were not apparent, if they were sudden or unexpected, or there was a sudden oil slick or something, then I disagree with his Honor's reading of the statute. Based on what I understood him to say. Understood her say.
Here's the issue. The testimony is that your car left the roadway. That is the prima facie evidence that you were not traveling at a speed conducive to the weather conditions and the road conditions.
It might be prima facie evidence, but it is not conclusive. See, that's like the thing, like also that is problematic here. So the idea of prima facie is basically probable cause. That's the prima facie case, is probable cause. So is there probable cause to believe she was driving too fast for conditions? Yeah, car go in ditch, but I don't necessarily think it's sufficient it's sufficient. So I'm not sure I agree with his Honor's reading either.
You can make that argument, but what I need to hear before I make a ruling, is we're getting way far afield of the information I need, is whether or not your car, you had an accident where you left the roadway that day. I have a testimony that you did. If you would like to provide testimony that that didn't happen, that would be relevant for this citation.
So none of the road or weather conditions are relevant to this action?
No, ma'am. I sit here all winter, every year.
See, I don't think that's true because the statute itself talks about the road conditions. If she read the right statute, the statute itself talks about road conditions. And so the road conditions are relevant, particularly as they appear or could otherwise be perceived. The road conditions are relevant.
Getting this citation. If you have a slide off, even a one-car slide off, you will get this citation. We cannot give a ticket to the road for being icy or to the weather for being snowy. We live in Michigan.
But
People were driving all day long on 131 and not having accidents, but you had an accident. That's why you have.
That is piss poor reasoning. That is piss poor reasoning, at least legally, right? Everyone else didn't scan off the road, therefore you must have been reckless. It's like, no, that's not true. You know, maybe there was some condition in the road. There was some slick that my tire just happened to hit or whatever, right? Or maybe the slick just happened. Maybe someone spilled some oil, or maybe the conditions just changed on the road because it just froze over. It just did this or it just did that, right? So like everyone else drives all over the time. Doesn't really, no, I don't like the judge's reasoning. Her reading of the statute makes more sense to me.
This citation. The defense to this citation would be, I didn't have an accident.
Well,
I don't think the mere fact of an accident is sufficient to prove the case. I don't think the mere fact of an accident is sufficient to have the case, because the only way accident would be sufficient is if you could say that an accident means that you were not necessarily operating with due care. And I don't know that necessarily can conclude that. You know, especially when you're talking about road conditions and a lot of other things. Like, it's not, I don't think that that's correct. Yeah. I think, yeah, it's Michigan statute 257. We can look it up ourselves, right? So, you know, I'm not a Michigan lawyer, obviously, but yeah, this looks right to me, right? So this looks like the right statute. Michigan law 257-627. This looks right. And remember, to be guilty, you have to violate each and every element of the statute, right? So you have to find sufficient evidence to prove beyond a reasonable doubt of each and every element of the statute. So let's read the statute like a lawyer. All right. An individual operating a vehicle on a highway shall operate that vehicle at a careful and prudent speed, not greater nor less than reasonable and proper. So you have to behave reasonably, having due regard to the traffic, surface, and width of the highway, and any other condition existing at the time. But you only have to have due regard, which again is, right? You only have to have due regard. You don't have to have perfect knowledge. You just have to have due regard. You just have to be paying attention. So if it is not readily apparent what the traffic surface or width of the highway or any other condition existing is, then, you know, I tend to agree with her rating. So in my humble opinion, her reading, I think, is the superior reading. Yeah. As like, so how can he conclude, right, that she wasn't driving at a careful and prudent speed, having due regard? How can she testify as to the due regard? It seems like her reading is better, and she's asking questions to show holes in the state's case. So I think I agree with her. I think I agree with her. And maybe there's case law interpreting this differently than the statute would read. So that could be the case. Maybe there's case law that says something different than that. But my reading, I think she was asking reasonable questions. Like, did you observe me driving? Did you see me? Did you speak to anyone? Right? What were the conditions of the road? Like, what were they? And so forth. Like, her questions seem perfectly reasonable to going towards the element of the crime. So I think I agree with her.
Cannot blame it on the road or blame it on the weather. That is not an option for me to not find you responsible.
I disagree with your reading,
I
sir.
would still find you responsible regardless of the weather or regardless of the road conditions. You always theoretically could have been driving differently and not had an accident. All right?
Yes, you could have been driving differently and not had an accident, but it doesn't mean that you weren't driving responsibly, I don't think, inherently. Right? Just because the accident occurred doesn't mean that you were necessarily negligent. Right? I mean, it would be true most of the time, but is it necessarily true all the time, right? Is it necessarily true that if you have a car accident, you're necessarily negligent? And the answer to that question is no, probably most of the time, but not necessarily all the time, right? You could get blindsided by, there could be a fluke accident. There could be a lot of things. Like negligence doesn't require perfection. It requires reasonable, prudent care of the reasonable and ordinary person, all that stuff, you know? Yeah.
Is predisposed to a decision on these tickets.
Well, no, ma'am, because I would be willing to hear you say that didn't happen. I didn't slide off the road, but you're not suggesting that or testifying that. You just are going in circles about road conditions and weather conditions. So what I'm saying is I give you an opportunity right now to present to me relevant testimony to my decision of whether or not you had a slide off that day.
The relevant testimony, Your Honor, is that I was traveling at a careful and prudent speed. And
no, you weren't, ma'am. Otherwise, you wouldn't have had an accident.
See, I don't think that that's necessarily true. I think that's a fault. I don't think that's necessarily true. Yeah, I don't know that I don't know that you can draw that conclusion.
It's the definition of careful and prudent, right?
No.
I disagree with the court.
Okay.
If I may specify, I would appreciate doing so.
Go ahead.
Thank you. I work in Grand Rapids and I live in Kalamazoo, Michigan, and I was on my way home from work.
It sounds to me like you need a formal hearing. It sounds to me like you're definitely going to need a formal hearing. Because I don't know the law of Michigan well. Maybe the judge is correct. Maybe that's what the case law says. Maybe she's wrong on the case law. But like based on my superficial reading of the statute, it's like I don't know. I think there's a legal argument to be had. So this judge may do this literally every single day, but judges make mistakes, and I think there might be a case to be made that he's making a mistake here. So, and she was trying to prove her case or prove the state's case or show the weakness of the case by attacking the elements. Like, did you see me driving? Did you talk to anyone who did? What were the conditions of the road? Did you observe them? And like, so she was asking questions that seemed to attack the statute to me. So I don't know. I don't know. So maybe Angelique is indeed a good attorney. Maybe she's a very good attorney. Maybe she's reading the statute correctly. And incidentally, even if she's reading it wrong because of the case law, she wouldn't necessarily know that. Not every attorney knows every case. I certainly don't know every case that's ever happened. So maybe there's a case out there that says she's wrong. Maybe the courts have already opined that, merely losing control is dispositive, right? Maybe that's the case law. But the judge hasn't said that. The judge hasn't said, well, according to such case or so-and-so case. He's just saying, well, I do this every day and blah, 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 blah. It's like, okay. So I think Angelique Camfield she might be she might be on the right side. It sounds correct. Sounds plausible to me. And the judge is not allowing her to ask the questions necessary to preserve the case. So she really needs a formal hearing is what she really needs.
You'll have to forgive me. This, when I talk about this accident, it's very traumatic and it makes me extremely upset. I haven't had a citation in over 20 plus years.
Okay, now we're off point.
My last ticket was when I was in my 20s on my way to law school.
Okay, none of these are relevant. This is definitely not relevant.
And again, that's a relevancy issue. It would be unfair of me if I looked up your record and made decisions on this case based upon whether you did or did not have tickets.
Yeah, that would be fair.
All I have to do is decide on January 10th of this year around 5:04 p.m., did you slide off a 131 or not?
See, that's not all you have to decide, Your Honor, and it's pissing me off a little. It's not, did you slide off the road? That's not what the statute says. The statute doesn't say anyone who slides off the road. It says that you shall operate the vehicle at a careful and prudent speed, not greater nor less than reasonable and proper, having due regard to traffic surface and width. It doesn't say sliding off the road is illegal. It could say that, but it doesn't say that. It talks about how the individual's operating the vehicle, not necessarily what happened to the vehicle. Now, what happened to the vehicle can be strongly suggestive of operating the vehicle. Those can be the same thing, but it's not necessarily the same thing. And you're making the wrong argument. So it's like, all I have to do is prove that you slid off the road. No, you didn't. That's not what the statute says. I'm with lady lawyer over here, Angelique Camfield. Angelique Camfield is reading the statute. It seems to me better than the judge. Judge says, all I have to do is prove you slide off the road. No, that's not what the statute says. I can read, God damn it.
The only thing I have to decide, I already have evidence provided from the deputy that did in fact happen. This is your opportunity to present evidence to me that it didn't happen.
Well, I was driving at a careful and prudent speed, which is part of the statute.
Ding, 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 ding. Yes, it is. It's part of the statute. It is. That's the standard. That's the standard. Driving at a prudent and careful speed. That's the standard. Not whether you slid off the road. Whether you slid off the road might be strongly suggestive of that you didn't do that, but it's not necessarily one and the same thing. God damn it.
And just that the fact that my car went off the roadway does not mean that I was not. There were 20.
I agree. It's not the same thing. It's not the same thing.
2 accidents between mine and the hospital the EMTs were taking me to. They told me that. And it wasn't that every single person was driving too fast for conditions. I had just driven. So when I left my office.
By the way, just to prove the point, okay? Just to prove the point, even if the accident never happened, you could still be guilty of this statute. Even if the accident never happened, you could still be guilty. If the car never slid, if nothing ever happened, you could still be guilty, because what makes you guilty? Operating the vehicle at other than a careful and prudent speed that's reasonable and proper, having due regard to traffic, right? That's what makes you guilty. The operation at a non-prudent speed without due regard. So you can be charged and convicted under this statute even if the accident never happens. That's how you know they're not one and the same. That's how you know they're not the same thing. It's reckless driving. That's what the statute is. It's reckless driving. You're driving in a reckless way, or at least a negligent way, depending on how we read the statute, at least a negligent way. And if the accident never happens, is it possible? Just ask yourself, is it possible to violate the statute and the accident never happens? And the answer to that question is yes. So they can't be one and the same. They can't be one and the same.
It took me 20 minutes to clear off my car. I'm very, very careful to make sure that my lights aren't covered. There's no snow on my roof or anywhere else. My plate is visible. I'm very careful with that. And I had just driven through an accident. I don't have a clear recollection, but it was either just at the south end of the S curve or towards Caledonia. And I was being very cautious because I was trying to get...
Right, and this is relevant testimony. I know she's crying and she's a little emotional, But she's like, I'm a careful driver. I take care of my car. And I was driving in a careful way. Well, that's what the fucking statute says. That's what the fucking statute says. It says driving carefully. That's what it says. And she's like, yeah, I take care of my car. I'm a responsible driver. I was driving carefully. That's the fucking statute. She's making the right arguments. God damn it.
Home safely and have a weekend with my daughter because her sister was out of the state at a soccer tournament and I just wanted some time with her. And I remember that I texted over the Bluetooth my staff at the office and I said, be very careful, the roads are bad. And then I called my daughter over the Bluetooth and said, honey, I'm going to be late because the roads are really, really bad. And I just passed an accident and I'm taking my time.
Ma'am, I'm going to caution you. Did you just testify that while you were driving, you texted?
Over the Bluetooth. It's the voice to text.
All right.
I do not
Oh.
hold my phone while I'm driving ever. And I always wear my seatbelt. So I let them know that I was going to be later because I was taking my time and being cautious. When I got into Allegan County.
And she did say Bluetooth earlier. The judge just missed it. This judge is pissing me off at this moment, to be honest. The judge is pissing me off.
The roads were worse and the visibility was lower. And I'm hesitant always to change lanes in that weather because in Allegan County in particular, the road conditions.
None of this matters. If the car left the road at all, she gets the ticket. But she shouldn't. Because that's not what the statute says. That's what the judge says. The judge says, well, if it left the car, if it's skidded off the road, that means you're guilty. Blah, 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 blah. That's not what the fucking statute says. It says other words. It says other words. Don't replace the words of the statute with other exciting words. Okay? Don't replace the words of the statute with other exciting words. Just read the words of the statute that are there. Just use the words that the legislature wrote. In their infinite wisdom, this is what the legislature wrote. Maybe they should have wrote other exciting words, but they didn't write other exciting words. They wrote these exciting words, and the legislature can do no wrong. So just stick with that, and you'll be fine. Damn.
Really bad at clearing the roads. I've driven in this state. I've lived in this state my whole life. I know how to drive in the winter and to be cautious. And
the judge doesn't give a shit. The judge does not give a shit. He's like, I don't care. This car skidded off the road. That makes you guilty. The car's off the road.
Also, I was hit on I-94 in 2021. I was
okay. This is off point.
You are telling a very long and involved story that is irrelevant to the decision.
It got irrelevant, but it was mostly relevant until the last three words. It was pretty relevant until the last three words, and then she went to 2021. It became irrelevant, but the judge thinks it's all irrelevant because the judge can't fucking read the statute. Even though, incidentally, she quoted the statute to him. And then the judge says, well, I do this all the time. I'm very familiar with the statute. Are you, Your Honor? Are you sure you're familiar with the statute? Maybe give it another pass. Maybe give it another pass. Or if there's a case saying what you're saying, cite it. Cite the case. Maybe the judge knows the law, and maybe the Court of Appeals and or the Supreme Court of the state has opined exactly this. Maybe that is the correct interpretation of the law. But what he could say was, according to case so-and-so, merely skidding off the road is sufficient. It says so in People v. Bullshit. 585 Southwest 2nd bullshit 386 pinpoint site 413 merely skidding off the road is sufficient, blah, 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 blah. But he could say that, but he's not saying any of those words. He's just simply saying, I've been doing this a long time. I know the statute. I'm familiar with the statute. The road conditions are irrelevant. Even though the traffic surface and width of the road and any other condition existing at the time. Well, that's interesting. Any other condition. any other condition, and yet the conditions of the road are somehow irrelevant, even though any other condition is right in the text of the statute. It's amazing. The conditions of the road aren't relevant except for the fact it's literally in the statute because I can fucking read.
I have to make today.
I'm trying to explain what happened.
How is anything that you've told me so far going to explain whether or not you left the roadway or not?
Because it tells you how it happened.
Yeah, it tells you how it happened. That's the thing. That's the thing. Like how, listen to the judge's answer and listen to what she says. That's it.
You left the roadway or not? Told me so far going to explain whether or not you left the roadway or
Wrong question.
not.
Because it tells you how it happened.
Right answer. Wrong question, right answer. How does it tell me whether or not you left the roadway? It doesn't. What it does tell you is how I was operating the vehicle.
I was being careful.
No, it doesn't, ma'am. The fact that you were in an accident in the past on a different road has no bearing on what's happening here.
It does, because I was rear-ended and slammed into the vehicle in front of me, and it caused me trauma. And there was somebody that was coming up really fast behind me, probably a truck, I can't remember. Because I get really nervous then when they're behind me so fast because I've already been hit. So I slowed even more.
What's this judge's name? Daniel. I can't quite read his last name. Is it Hendrick? Daniel Horick? Looks like Daniel Horick. Daniel W. Horick. Judge Horick, you're a douchebag. Read the statute harder. Try harder. Norbeck? Okay, Daniel Norbeck. Hey, Daniel, you're a douche. Try reading the statute harder. Give it another go.
And wanted to put my indicator on and checked my mirror to make sure it was clear. And I started to merge over so I would get out of that person's way. And then the slush was pretty deep. It was about maybe 3 or 4 inches of slush between the lanes, and it caught my tires. And there wasn't anything that I could do. I wasn't driving too fast. I was trying to slow down even more and get out of that person's way.
Wow. Wow, that sounds like, let me think about this. There was another person on the road and they were driving too close to me, and I get really nervous because of a prior accident. And so I was trying to get out of their way. I was trying to slow down, trying to get out of their way. And there was nothing I could do because of the road conditions. There was nothing I could do. Oh my God. It sounds like she's testifying about how she operated the vehicle at the time. Wow. Someone can read the statute. It's not the fucking judge. Holy shit. You're wrong. I can fucking read the statute. Fuck you. I can fucking read. Fuck you. I'm right. I can fucking read the fucking statute. Fuck off.
Very careful on the road.
Anything further you wish to tell me, ma'am?
Just that
This judge is close-minded and a fucking idiot.
I don't think a preponderance of the evidence demonstrates just because I was off the road that means I wasn't driving carefully and
Right. It doesn't necessarily mean that. It doesn't necessarily mean that. The only question you have to ask yourself is it possible? Is it possible to drive? Is it possible to operate the vehicle carefully and prudently at a speed not greater nor less than reasonable and proper, while having due regard to traffic service and width and any other condition. Is it possible to do all those things and yet slide off the road? Is it possible? Is it possible? And I think it's possible. It doesn't require perfect knowledge. It requires due regard. It doesn't require perfection. It requires being careful and prudent.
Prudently. I was even informing people how bad it was and saying to be careful.
Okay, ma'am, so for purposes of informal hearing, I would find that the deputy has met their burden and that you...
Of course you would, because you're a fucking tool who can't fucking read a fucking statute, you fuck ass. Fucking piece of shit, fuck judge. Fuck you, you fucking piece of shit. So-called, Your Honor, fuck you.
are responsible on this citation. Now, because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. I want to take this to formal hearing.
You should absolutely take it to formal hearing because the judge can't fucking read a statute. You should 100% take it to you should 100% take it to a formal hearing and shove it up his honor's ass.
Formal hearing is in front of the district court judges. It involves the prosecutor's office. But to get to formal hearing, you must do two things. First is you must ask for formal hearing within 7 days of today's date. That window of opportunity to contest this further closes after 7 days. And two, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
Yes, I don't know how much the ticket is.
I can tell you that.
I bet you can. I bet you can tell you how much it is.
10 or 135, depending on whether or not they put the accident on there.
I'm with Angelique. I'm with Angelique. Angelique was asking the questions the statute contemplates. She was using the language of the statute. She was asking the cop, did you observe me? Did you see me operating the car? Did you talk to anyone who did? Did you talk to any witnesses? What were the conditions of the road? How long did it take you to get there? Which might incidentally be an indication of the condition of the roads. Where were you? How long did it take you to get there? That might be indicative of the road. That she's asking questions that are based on the statute. She's reading the words on the page.
$135. So if you come in and post that as bond and then request
Someone please tell the judge for the Allegan 57th District Court I said he was a douchebag who can't fucking read a statute. Try fucking harder.
formal hearing within 7 days, you'd get another bite at the apple. I will tell you the problem that formal hearing will also be that road conditions and weather conditions are not a legal defense to this ticket, but you're...
They should be. They should be because it's in the statute. And if that doesn't work, then we can go to appeal. We can go to the Court of Appeals. Shove it up their ass.
Free to exercise your rights. But we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
Is she judge material? She's more judge material than whatever piece of shit is sitting on the bench right now. This fucking piece of douchebag, fuck ass, so-called Daniel, so-called Norick, piece of fucking shit, and the Allegheny 57th District Court fucking tool. God damn. Pisses me off. I'm done with this fucking court. Fuck you. Fuck you. He didn't once cite a case. He didn't once cite any operative law. He misquoted the statute in its elements. He apparently doesn't know. Apparently, judge is confused that in order to be found guilty, you have to violate each and every element of the statute. And I'm reading the words and I don't see slide off the road anywhere. That's not an element of the statute. I don't see it anywhere in I don't see the word slide anywhere in there. It's not an element of the statute. It's not in there. Fucking shit. So I'm with the lady. I'm with you. And if you're wrong, if you're wrong, you're only wrong because there's a Court of Appeals decision that the judge didn't tell you about, which makes him a bad judge. All His Honor had to do is say, there's a case called, piece of shit versus court. And piece of shit versus court says that merely sliding off the road is sufficient and blah, blah, blah. And that would have been great. But he didn't cite one case. He didn't cite a case. He didn't cite any controlling authority. Fucking piece of shit. I think this lady deserves to be a judge because she can fucking read a statute. She'd make a good judge. Because she can read, which apparently has gone past the attention of this court. She went through all this to avoid a $135 ticket. As to that, Mandy, all I have to say is this. She has the right. She has the right. It doesn't matter if it's $1. It doesn't matter if it's life imprisonment. The government still has to prove its case. They have to prove each and every element of the case. She decided it was worth it to fight the $135. She has the right. And it's the government's burden to prove each and every element of the statute. And she was asking questions that are relevant. And the judge cut her off. And God bless her. God bless her, because people fighting tickets sometimes leads to U.S. Supreme Court cases. People fighting tickets sometimes leads to massive changes in law. Not usually, but every once in a while, a case goes way out of control. The number of cases with very humble beginnings that wind up at the Supreme Court would shock you sometimes. Some cases have very banal, very basic beginnings. And sometimes they wind up at the U.S. Supreme Court. So the $135, she has the right. God bless her. That's what I have to say to that, man. God bless her. What date was that posted? It was posted 1 day ago. Weeds for $10 says, I'm on Cacho's beat, but literally goddamn laughed, literally lolled at Michigan statutory analysis. I tell you what, man. I tell you what. Yeah. And they bullied her and they demeaned her and they laughed at her for asking fully relevant questions under the statute. Pisses me off. I was having a good day. Although I will say that my Discord mod predicted this 100% wrong. So Kestrel, who posted this, and I love Kestrel, she's a good mod, but Kestrel thought I would be shredding the lawyer. Kestrel said in the Discord message, she said that the lawyer is awful and said, I'm only a few minutes in and can hear Kurt shredding the lawyer in my head. Nope. Kurt did not shred the lawyer. Kurt shred the so-called judge. That's what happened. All right. What else is going on that we can talk about? All right, let's talk about this case because this is fun. All right, in irony of ironies land, the super chat, I thought I read them all. New York Renal MD, who's been a month for 37 months. Thomas, been a member 52 months. Kathy, your realtor in Jersey, said, so great you pulled up the statute. You better believe it. New York Renal MD for $5 said, baby in the road. She swerves to avoid the baby. The mere fact she goes off the road, she gets a ticket in Michigan. No wonder Flint's water's fucked up. You better believe it, right? Although strictly speaking there, the argument would be arguably necessity to justify the infraction rather than a mere, but either way, right? It's like the argument there would be necessity. I broke the law because I had to. Which is a valid defense. Necessity doctrine. I broke the law because I had to solve a greater evil. Lulu gifted the membership and Lulu became an uncivilian. Thank you very much for your contributions. I appreciate it. Yeah. Yeah. So if you swerved to avoid the baby, it might be reckless driving by the statute, but the defense is necessity if they ever charged you, right? Yes, I did reckless driving, but I did it to avoid running over the baby. I handled my car in an unsafe condition. I did it to avoid the baby. Necessity doctrine. I broke the law because I had to. All right. In irony of ironies, an AI expert's testimony collapsed over fake AI citations. So this was a great story in Stupid. This was a state's witness, I believe. This was the government's witness. I want to say the attorney general. I want to say it was the attorney general who did it. Whatever, it doesn't really matter. But this guy's an expert in artificial intelligence. And he submits an affidavit in this situation saying that AI technology is dangerous and it needs to be careful. He submits a goddamn affidavit saying AI technology is dangerous and we need to be careful with it. And his affidavit was generated with ChatGPT, the witness expert on AI. The expert witness's affidavit warning of the dangers of AI was generated with ChatGPT. This is a new level of stupid. It's a new level of stupid. In a twist that perfectly encapsulates the risk of artificial intelligence in the courtroom. Hey, people in court, nice video. Yeah. Hey, people in court, nice video. Yeah, this lawyer saw it very differently. So there is a different perspective for you, and thank you for being here and spending some time with me. In a twist that perfectly encapsulates the risk of artificial intelligence in the courtroom on January 10th, a Stanford professor hired as an expert witness in a lawsuit about AI-generated deepfakes had his testimony thrown out after it was revealed that the AI itself had hallucinated citations in the affidavit court filing, which is just the extra stuff. You need to change the title. I'm not a lawyer. That's fair enough. Yeah, and if you want to excerpt my thing and post it on your channel, you can post it. And then people can tell me how I'm wrong. I look forward to that. People can tell me how I'm wrong and misreading the statute and how sliding off the road is definitely the same thing. And it can't be the same thing. Sliding off the road can't mean automatically that you violate the statute, because you don't need to slide off the road to violate the statute, right? You don't have to leave the road. All you have to do is drive in unsafe conditions. Basically, in so many words, right? That's what the statute says. Read the words. What do you have to do, right? You have to drive in unsafe conditions, not reasonably and prudently, too fast or too slow. Keep, blah, 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 blah. So you can stay on the road. You don't even have, your car doesn't even have to swerve. Your car can remain 100% on track, never even wiggling one iota, right? It doesn't wiggle one iota. But is it possible to violate the statute? Yes, it is, because you drove too fast, given conditions on all the rest of it and blah, blah, blah. Now, how do you prove all that if the car never wiggles is a really good question. But at least in principle, right, they're not one and the same. You don't need the car can remain completely in normal operation as long as the person operating it is not operating it prudently, right? So if you were driving 150 miles an hour, although the scenario is a bit unlikely, right? If you were driving 150 miles an hour down a one-way road at night with no headlights on, and there's an oil slick there that you somehow know about because you see the oil tanker, right? With a sign that says oil, 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 as it's spewing oil onto the road, in some sort of trajectory, and you're going 150 miles an hour on this one-lane road as it's spewing it in wintertime at night with no lights on and it's overcast, and you're spewing down the road, and somehow your car gets through all this with nary a wiggle, Were you reckless driving? I think you were. So, right, they can't be one and the same. They can't be one and the same. In a twist that perfectly encapsulates the risk of artificial intelligence in the courtroom. All right, what happened in this case? Yeah. The case in question centers around a Michigan law banning AI-generated deepfakes designed to influence elections. Let me know how it turns out, by the way, if you decide to post an excerpt of my video on your channel. Let me know how it turns out on your channel. I'm sure there will be any number of people who say I have my head up my ass. I'm looking forward to their in-depth legal analysis, so it should be great. By the way, all they have to do is post one citation to a case that basically says that she's guilty because of this reason, will be fine. And then I would even concede the point. But then even then, my point would be the judge didn't say it, so he doesn't know what the fuck he's talking about. So even if they're able to prove it, even if they're able to pull up a citation, well, actually, according to In Re Douchebag versus Michigan, it clearly says, the Supreme Court of the state clearly says that, you know, if you're doing this, well, it's like, well, maybe the judge should have mentioned that. That would be really nice. The state enlisted Jeffrey Hancock, a Stanford professor specializing in communication and AI, to support its argument that such deepfakes pose a legitimate threat to democracy. But in an ironic twist, Hancock admitted that he'd used ChatGPT-O to help draft his filing. It's not really an expert filing. It was worse than that. It was his affidavit. It was sworn under oath. It was sworn after oath. The next case is way more interesting, though. Okay, maybe the next case will be even more interesting. Yeah. And that's where things went wrong. The AI hallucination, a well-documented flaw of generative AI, produced multiple entirely fabricated citations that seemed authoritative but referenced non-existent sources. The judge then struck the testimony from the record, saying his credibility had been shattered. Yeah, I'd be about the same as the judge. I'd be like, your witness is no longer allowed. Yeah, that's a fail. The party, and I believe it was the government, I want to say it was the Attorney General offer who proffered this bullshit. The Attorney General's office is like, can we file a corrected declaration? And the judge is like, no, you can't. No, you can't file a corrected declaration. I'm striking it all, and you can't use that witness. And I'm over here saying like, good decision. Good decision, right? I no longer have faith in you as an expert given this. No, you can't fix it. Go away. I'm sold. Yeah, it was the Attorney General's office. I know I was right. The Attorney General's office requested to submit a revised filing, but the judge said go to hell. Yeah, I'm with the judge on this one. You know, I'm with the judge. This is not a typo. This is an expert in AI saying I'm an expert of AI. In my sworn declaration, AI is really dangerous, and I produced it using fake citations using AI. And the judge is like, no, you can't file a correction. Go to hell. I'm with the judge on this one. I stand judge. I stand judge. The expert on AI hired to warn about the degrees of AI was himself undone by the AI. Yeah, I'm with the judge on this one. That's a pretty big fuck up. Find an expert who's actually qualified. Go away. I stand that decision. That's a good judge. Good judge. Try like harder. Try like at all. Try at all. All right, where else are we on this thing? All right, great. In you can't touch the merchandise news. You can't touch the merchandise news. A prostitution sting has come undone because we touched the merchandise a little bit too much as the police. Yeah, that's, yeah, you know, yeah, you can't. For nearly 2 years, the Louisville police used questionable tactics to arrest women for prostitution. Those cases fell apart and the officers themselves are being investigated. The department's internal report lists more than 2,000 pages and 50 interviews. From October 2022 to July 2024, officers in the street crime unit visited different locations posing as customers willing to pay. Up to that point, they're doing fine. Up to that point, they're doing fine. In a sting operation, they're focused on probable cause. For Louisville prostitution stings, that means all the officers needed is a verbal commitment. That'll be fine, right? Will you sleep with me for money? I sure will. How much money? $300? $300, that's a deal. All right, let's go sleep together. Congratulations, you have now proven your prostitution case. Congratulations, right? But unfortunately, it didn't stop there. One of the leaders in the sting operation discussed with Internal Affairs regarding one of his cases. The Internal Affairs investigator said, you agreed to $400 to F both of the women. Excuse my language, but I'm just reading what's in the report. So that's your probable cause, right? It sure is, right? We reached an agreement. $400 for sex for two? Two for one special day? Okay. We got ourselves a case, man. We can pack this thing in. But then after that, you stay and ask them to get undressed. And you know they're naked. And you know they're massaging you and grabbing your penis. Yeah, okay. The detective, well, we don't just walk out. IA, why not? You have enough. The detective, I don't know. IA, you have probable cause. Why not walk out? Why not break contact? I have no idea. Well, that's a really good answer. You have everything you need. You have everything you need. You have an agreement for prostitution. You have a quid pro quo, right? You have a tit for tat, or is that the other way around? A tat for tit. Yeah, that's what you have. You have a tat for tit in this situation. And that's all you really needed, and then you decide to do other exciting things. He later told internal investigators that he's trying not to reveal himself as a police officer so the one would become suspicious. Internal Affairs says the following, quote, I'm trying to get into your mindset because I've had other undercovers say they wouldn't do that stuff, even if it blew their cover, because that's a bullshit excuse. This isn't a cartel. It's a massage parlor. Who gives a crap if we blow our cover? The detective. Again, this was the city pushing us close to this, close up. Oh, it's the city's fault. It's the city's fault for telling you to go to the prostitution whorehouse. Oh, that's the problem. You are the police. It's the city's fault for telling you to go to the prostitution house and try to uncover evidence of prostitution. It was the city's fault for putting us close to the whores. Okay, that's great. So it's not like the cartel where the city doesn't see it and doesn't bother us about the drugs. I get it. I'm just trying to figure out and understand where we went from compliance checks, fully clothed, to getting hand jobs. Something went wrong somewhere, and I can't get anyone to pinpoint it, the detective, and I can't tell you exactly when it happened. Internal Affairs says, quote, at what point is it too much? It sounds like nothing is what you're telling me. No, if they're being aggressive and trying to have sex with you, that's enough, whether they're touching. Then why didn't he leave? He was there for another 18 minutes. That's what I'm saying. The sergeant, but you're reading that with the perception of not being in a covert operation and laying on the table and just talking through it. And you're saying he was touched that many times, but there's nothing that says he was touched that many times. The investigator, he didn't write it, but it's on audio. The sergeant, he could be saying that to send them away, to break contact, but they're not. The sergeant, there's no video, right? The IA, if there was, we wouldn't be sitting here. And I wish there was. But this could be an attempt to, because everyone has listened to this audio is like, oh my God, what is this guy doing? IA is not buying this story. IA is not buying this story. They are not sold. Another officer, more fun questions from Internal Affairs. Internal Affairs asks, so the first one, when you went in with no recording device, was someone outside? Did they drop you off or did you drive yourself there? I drove myself. So just pulled out of patrol, given some city money, and told to go and see if you can solicit something. The officer, yes, sir. I said, I was told, hey, make sure you bring some clothes today if you're going to do it. Because then they asked me like a couple days before, hey, make sure you bring clothes this day. I showed up at the office. I was given money and given the brief. And it was discussed whether someone would go with me. And they said, no, you're fine. You can do it. So bring some street clothes. Bring some street clothes. For the undercover operation. The officer said, hey, he said, since it's your first time, we'll take it easy on you. So we go here, there are pretty girls there. You need to make sure that she offers it to you. That would be really helpful so you avoid entrapment defenses, right? It'd be really helpful, although it would be nice. It would be nice if you can get her to make the offer, right? Not necessarily required, but would be bonus, right? You need to make sure she gets the offer to you. Go ahead and give it to someone to show her how much money you've got or whatever. And if she touches you, let her touch you. And then once she touches you, you can break contact. Right, that sounds sufficient. According to Internal Affairs, the recording device picked up not just one touch, but several minutes of physical contact between Dunn and the woman. Investigative Affairs asked the following question. What caused you to go over 4 minutes of getting a hand job over almost 5 minutes? If your instructions were, once the deal is made and they touch you, you need to break contact. The officer, I was trying to ask her questions as far as like, hey, what's your name? They didn't ask me to do that. They didn't ask me to get her name. They didn't ask me to get any of the questions I'd asked on the recording. That was me just trying to be proactive. Exciting. I kind of feel for Internal Affairs on this one. I kind of feel for it. It's like, can you give me any explanation? Any explanation on any level that makes any sense? And the answer to that question was no. No, we can't. Great. 10 weeks after Dunn filed his report, the description of his interaction with the woman was altered to remove some of the graphic details. Well, that's interesting. The police report was altered. That sounds suspicious. That sounds muy suspicio. In a second interview, Dunn eventually admitted that someone else made changes to the narrative as Dunn watched. Oh, that's great. One officer is making changes to an official report. As the officer watches, he make changes to the official report. Let's see. Obstruction, filing a false report, destruction of government documents. I'm sure I can think of some other things if I give it a thought. Oh my God. Plyben told the IA detectives that his superior asked him to clean it up. My superior said, this report looks pretty bad. And I was like, I understand, sir. But I told him he needs to tell the whole truth in there. And he's like, no, I understand. He's like, is there any way to clean it up when it's still factual? But it doesn't look like he was going for 20 minutes in there. Exciting and cover up. So let's see. Breaking my oath. Official corruption. Destruction of documents. Obstruction of justice. Also, of course, prostitution, because we engaged in prostitution. According to Montoya, he didn't remember reading a lot of the reports, but Dunn stole out. The sergeant. The verbiage he used where the lady began to touch him. I remember reading that. Internal Affairs. Was it the verbiage he used or that he was getting touched? The sergeant. Well, I wasn't sure. I remember I put in Plyben, the lead investigator, and said, hey, what? The person was briefed. Look at this narrative. Do you think it happened? The response is, I don't believe so. So it was just written incorrectly. Uh-huh. I'm sure that's the problem. Louisville PD did not have a written policy regarding what the officers could do in this situation. Officers told IA detectives to go as far as they're comfortable as long as they didn't finish. Ew. Officer Michael Hernandez, if you're touched inappropriately, you need to break contact. Don't do it for gratification. Don't finish. Don't ejaculate. Make up an excuse. Get out of there. Plybin said he gave the same advice to male and female officers he recruited. Internal Affairs. What do you mean by that? The officer don't orgasm. Wow. Wow. A records clerk told IA detectives that street crime officers were bragging about everything gets done to the massage parlor. She said she heard them ask a male coworker, another clerk, to go undercover, telling him, if you want to come and see for yourself what you can get done, we'll have you go out. Oh, that's nice. Officers are pimping each other. How nice. After interviewing a male clerk, IA detectives called in Detective Lyman for an interview. IA. Okay, do you remember exactly what you told him? Because if you could remember, it would be helpful. The detective. I understand, but I don't. I tried recruiting a lot of people. I couldn't tell you the exact words I told him. It wasn't that important a conversation. IA. It wasn't a joking thing like ha. The detective. I know I wouldn't have joked like that, not about having sex. IA. Not about the hand jobs or the blow jobs while laughing. The detective. I can tell you, like I said, I wouldn't have told him that. He's making it sound like he could have sex. No, I would never even joke like that. When you recruited other people in the PD, did you ever jokingly say you could get a free hand job or anything like that? A free hand job? No. You never joked one time? Yeah, joking around. Oh, so you might have said it. Oh, okay, that's interesting. You might have said it. I might have told one of the officers just to make sure to tell you break contact, but that was jokingly. Oh, the truth is coming out slowly but surely. Did you say it? I said it only as a joke. Only as a joke? Okay, I might have said it more than once. Right? The truth comes out slowly but surely. This is exciting. This is exciting. Another interview with, okay, we're going to talk to a captain now. Things are getting more exciting. Let's go up the ranks of police officers. Let's talk to a captain. I'm sure this will be fine. Internal Affairs, we're looking for some insight because we're also trying to wrap our heads around how did the PD get to this place that's been going on for 2 years? The captain, I don't really know if you want my personal opinion. IA, yeah, sure. The captain, I think they weren't supervised, and I think they went wild and did whatever the F they wanted to. And they went in there to get some hand jobs and realized they could. And about every time they wrote it down. About every other time they wrote it down. Personally, I think that's what happened. The detective. I don't think there was ever a question of, hey, are we doing this correctly? Really? You didn't once ask a question? Are we doing this right? You never asked a question? That's good news. Internal Affairs. Right. But the problem is the DA's kicked back all these because it's a problem. The detective. Right. Internal Affairs. That's the problem. They're saying you can't do that. They gave the chief examples from other agencies of how you can do it. But our guys, they're way across the line. So that's why we're doing it. I don't know, strictly speaking, that the police can't do this, but do you really want to go into court with that? That'd be good, right? Do you really want to go into court with that? Okay, let me bust these women for prostitution. Let me get the officers on the stand and they can talk about the hand jobs they were being given. Yeah, I'm not sure I want to prosecute that case either. I think I might take a pass. The department was forced to drop the case and return $250,000 in cash seized from the massage businesses. Great. Just great. Two sergeants and a detective were fired. 8 others suspended or demoted. All of them declined to comment. The Texas Municipal Police Association also declined to comment. The chief of police remembers most of the members of the street crime unit. He told the team he's rebuilding a new unit called Covert Operations. That doesn't sound like that's going to be a problem in any way. And is in the process of writing up a policy. That might be nice. He also referred to officers' cases to the Texas Rangers. This is a pile of stupid. This is a pile of stupid, and I don't know that I can do with any more stupid. That's a lot. That's a lot. All right, let's take a break and watch a guy try to run away from the police while the police are riding a horse. Can the guy on foot escape from the horse? Let's find out.
now. Get him. Get him now. Hey, get on the ground. You're going to get run over. Come on now. Come on now. Get him, boy. You better stop. You're going to get hit. Come on now.
The horse is now running through a
You
McDonald's.
gotta run us on the horse. You better stop. Jack, come on now.
Run him over, Jack! You better get on the ground right now!
Watch
You better
it.
get on
Watch
the
it.
ground right now!
Get on the ground.
Go ahead and have a seat.
Well, our guy involved in a drug deal was unable to successfully run from the horse. Don't run from the horse. In other people, is this, hold on a second, let me check this real video real fast before I play this, make sure this what is it purports to be. Okay, yeah. Hold on. All right, here is Florida man attempting to run from the police while wearing a onesie. Okay, great. Let's watch that. Uh-huh. Great. Okay. Florida man was recently arrested after leading authorities on a wild chase while wearing a Dalmatian onesie. Dylan Devereaux, 36, is charged with fleeing to elude, escaping, reckless driving, leading the scene of property damage, battery on law enforcement, assault on law enforcement, resisting an officer with violence, resisting an officer without violence, depriving a law enforcement officer of equipment, drug equipment possession, possession of a new legend drug, possession of methamphetamine, and petite larceny. That's a lot of things. That is a lot of things. Just after 12 a.m., troopers attempted to pull him for driving recklessly at a high rate of speed. Pictured here is Dylan Devereaux, 36. He is wearing a Dalmatian onesie. I mean, it will shock us all. He apparently was charged with possession of methamphetamine. I mean, take one look at this guy. Does this guy look like a methamphetamine user to you? Yeah. After initiating chase, Devereaux crashed into a tree and took off running. He was shot with a stun gun and fell to the ground. As troopers were handcuffing him, a fight ensued, and Devereaux was shot with the stun gun again. Devereaux escaped once more and took off running towards the wood with one handcuff on. Additional officers arrived at the scene and a 3-year-old canine tracked Devereaux to his nearby home. The suspect's girlfriend, this guy has a girlfriend? What am I doing wrong? What am I doing wrong? The suspect's girlfriend told troopers she didn't want them near her home since she... I'm sorry, I couldn't finish the sentence. I'm sorry. That was... My mind refused to accept that I was reading the words properly and refused to read the sentence. It just would not accept that was the next words of the sentence. We're going to give it another go, okay? Let's give it another go. The suspect's girlfriend told troopers she didn't want them near her home since she had drug inside and did not want to go to jail. Great. Authorities allegedly found drugs inside the home and arrested the couple. Great. It's great. It's fantastic news. Let's watch a courtroom brawl breakout. This apparently is a family of a murdered woman attacking the suspect in open court. Let's watch that happen. I could do without the music. New Mexico courtroom footage shows the moment a man accused of killing his ex-girlfriend was attacked mid-hearing. I'm just going to mute it because, audio issues. I don't need copyright claims. I have enough of that going on in my life. The violence erupted when Carlos, 40, and Pete, 51, leaped over the barrier at the district court. Now more people are getting into the fight. They charged the murder suspect, who was 21. Even more people are charging into the fight. More people are getting added to this fight. The suspect now has a taser in his hand. Everyone's punching everyone. Security cameras capture the incident, starting with the moment that one of the men charged the suspect while a police officer tried to stop them. As the three of them fell on the ground, Yassa joined in on the attack. Okay. We got also 3 inmates sitting in the jury box looking at let's like, what the hell? I think 3 inmates in the jury box are about to get some new friends. Other family members and cops tried to rush in and tried to defuse the situation, which further escalated. A woman tried unsuccessfully to pull the father's shirt after he tried to intervene. Yeah, this is going great. Yeah, lots of people getting arrested. It's going to take a while to figure out how to untangle that one. That's going to be interesting. Well, that was stupid. The brawl was finally dispersed when the officer pulled out a gun. Nice. Maybe a little bit much. He killed my niece like a coward, the man claimed, referring to the suspect after his arrest. All right, I think we got the gist from that story. All right. All right, let's talk about 2 things related to Trump real fast. Then we'll talk about, a couple things relating to Trump because they're kind of interesting. And then we're on our path to wrap this thing up. We got like 5 more stories left. And so we're on a path to wrap this up. But if you've got any other stories you want us to review, let us know. All right, so we'll start with some lawsuits relating to slow down and try to relax. Oh, I probably should slow down a little bit. That's fair. I'm just a little hyped I'm still pissed from the stream earlier, but I probably should slow down a little bit. But fair. Start over. Yeah, I should try to slow down a little bit sometimes. That's fine. All right, let's discuss this case. All right, so in Trump news, first thing is 19 states so far have sued to stop Doge from accessing Americans' personal data. Okay. 19 Democratic attorneys general have sued Donald Trump to stop Elon Musk's Department of Governmental Efficiency from accessing Treasury Department records that contain sensitive personal data. The case, which is filed in New York court, alleges the Trump administration allowed Musk's team access to the Treasury Department central payment system in violation of federal law. I'm by no means an expert on this issue, but my first thought on this issue is, well, the Treasury Department is obviously under the control of the president, and they're the executive branch. And so there's this idea that the president can empower anyone to do anything that he could do, or any of them could do, because they're all his power. So the only thing here that would be perhaps interesting is because Musk isn't really a governmental employee, and he arguably is even a primary officer under the meaning of the Constitution. So arguably, he requires Senate confirmation in order to do what he's doing. But I'm not an expert on such questions because this is a new agency. And I think the president can create new agencies. It's my understanding that he can. What it takes to hire a new employee for that new agency when there's no US code, because obviously it's new, I don't know. But the fact that Musk is not a governmental employee, as far as I'm aware, could be a problem, because if he's head of the agency, right? If he's head of the agency, he's arguably a principal officer and therefore requires Senate confirmation. So there is a problem potentially there. So there's some issues relating to that are potentially attackable. Also, of course, there could be statutes relating to governmental records that might be on point. I don't know the full issue there because it's interesting. The payment system that Musk has access to handles tax refunds, Social Security benefits, veterans benefits, and much more. Musk's Department of Governmental Efficiency was created to discover and eliminate what's deemed to be wasteful, which incidentally, I think there's been a lot discovered relating to that. So I think that's fine. Doge's access to Treasury records, as well as its inspection of various agencies, has ignited widespread concern among critics over the increasing power of Musk's, although he's found a lot of bullshit. So I think that is that point. New York Attorney General Letitia James, whose office filed the lawsuit, says Doge's access to Treasury Department raises security problems and the possibility of an illegal freeze in federal funds. This unelected group, which incidentally, everyone except for the vice president and the president who works in the executive branch is unelected. So the unelected thing doesn't get you very far because there's only two people in the entire executive branch that are elected: the president and the vice president. Everyone else is unelected. So calling them unelected doesn't get you where you need to be. That's not the thing. This unelected group, as opposed to the rest of the federal government, led by the world's richest man, is not authorized to have this information. And they've explicitly sought this unauthorized access to illegally block payments. And it's my understanding they don't block anything. They have read-only access, so they're not blocking anything, although they might provide recommendations to those who do. Payments for healthcare, childcare, and other essential programs. Letitia James, who's a Democrat, says the president doesn't have the power to give away Americans' private information to anyone he chooses. Also in the lawsuit are Arizona, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Minnesota, Nevada, New Jersey, North Carolina, Oregon, Rhode Island, Vermont, and Wisconsin, which are pretty Democrat-leaning all over for the basis. The suit alleges that Doge's access to Treasury records could interfere with funding already approved by Congress, exceeding statutory authority, which is a different issue, it seems to me. The case also argues that Doge access violates federal administrative law and U.S. Constitution separation of powers. Possibly. It also accuses Treasury Secretary Scott Benson of changing the department's longstanding policy for protecting sensitive personal information and financial information to allow the team for access. The Treasury Department said its review is about assessing the integrity of the system, and no changes are being made. So they're looking into it. Labor unions are also suing to block the payment review system. A judge has temporarily restricted the employees to read-only privileges, which I understand they only had in the first place. So there's a lawsuit over Doge, which isn't surprising. Then in a related story, I suppose, there is a judge who's temporarily blocked the federal government buyouts because those raise interesting legal questions, to be sure, relating to the availability of administrative leave, how much admin leave you can give, it rates how you get funding for that, and some other questions. So there's questions relating to that as well. So a judge has put a stall on that, which is not particularly surprising. A federal judge on Thursday temporarily blocked the Trump administration from implementing their fork in the road buyout offer until at least Monday. The district judge set Monday afternoon hearing to consider blocking the fork in the road offer. He has enjoined the defense from taking any action to implement the directive pending briefing of the oral argument, which makes sense. Basically, it's a TRO, temporary restraining order, while they figure out what the hell is happening. And that makes logical sense. There's no statute of Congress that explicitly allows for this. There is a statute of Congress that arguably limits administrative leave, although it can be read a different way. 40,000 people have apparently accepted the offer. So a lot of people have accepted the offer, but it's not clear that the offer is valid or legal. So, we'll have to see how that goes. So the judge described the brief hearing as a table setting session. He didn't say anything about the merits of the buyout. Lawyers for the Justice Department said they notify every federal employee who's subject to the bailout. More than 2 million federal employees had faced a midnight deadline on Thursday to accept the offer. 4 unions representing 800,000 servants argued the offer is unlawful, arbitrary, and result in dangerous 1-2 punch to the government. Would I recommend new or used if buying a watch for under $200? It depends what you're trying to buy, to be honest. But if you're buying used, I'd recommend trying to get it from, a fairly reputable source. There's some websites that are pretty good. Chrono24 comes to mind, and there's some other ones that are relatively good. I was looking at stuff on eBay. It depends what you're trying to buy. If you're trying to buy something that's $500 for $200, maybe you can get something good for $200. But, if you buy used, you run the risk you always get when you buy used. I mean, there's the inherent risk that it's not what it purports to be. It's fake, that hasn't been well maintained. All the risks that come with buying used. So, but if you're looking for a watch in the $200 price range for new, Seiko 5 is the first thing that comes to mind. Seiko 5 makes a lot of great watches in the 200, 230 range that are some really good watches. They make some dress Seikos that are really nice and some stuff like that. So if you want to buy new for $200-ish, Seiko's really good, and they make some fun stuff. You can also get the Casio Duro for $60 if you're looking to save money. I'd change the bracelet personally. I don't like the bracelet the Casio Duro's on, but I think it's a pretty sharp looking watch for $60, So get rid of the rubber bracelet, put it on a NATO or something, and call it a day. You want something professional that will last? Okay, yeah. So we can talk about watches for a second. So here's my recommendations. All right. So first choice is Casio Duro. Okay, there's this watch. This is the Casio Duro. This comes in black as well as blue. So there's a black, $50 on eBay or $50 on Amazon. Here it is with a blue dial. It also comes in with that blue. It comes with two-tone color. It comes with a green bezel. I wouldn't get the black. So $50, 3-year battery, very nice looking dive watch. Water resistant, 200 meters. Get rid of the rubber band. Put on a NATO, put it on a leather strap. $50, can't go wrong. Fantastic. And it's reliable, it's durable, it looks nice. It looks professional. Personally, I'd probably go with the blue because I think the blue looks badass for $54. You could put it on a blue NATO or something, or an orange NATO. It'd be awesome. $50 to you. And then you can also do, Seiko makes some great stuff for $230. So you could do something like this. Here's a Seiko 5 on a metal band. Diver, day date. This is an automatic. The first one was quartz. So this is an automatic. So that's a little bit more cool. It's a mechanical watch as opposed to quartz. The quartz is obviously more accurate, but the mechanical watch is more badass. Day automatic, no battery because it's automatic, and that comes in a couple different colors. You got black, you got a green, you got this gray that's pretty badass. You can do you can do with this large bezel. Then you can also do like this. This is like a dressy watch. It doesn't have a rotating bezel. So that's really good. That goes with a lot of things. That's $230. That one for $230. This one, this field watch for $214. Outstanding. 24-hour marking, automatic, red pointer finger. Very, very cool. Here it is in blue for $230. Very, very cool. So those are some recommendations for you. Get a Seiko, and Seiko makes a lot of great watches. Just search Seiko 5. Seiko makes lots of great watches. They make it in lots of good styles. Seiko is just a very well-respected brand, and it's something that will last and is very durable and comes in a lot of different options. Is there anything I'd recommend with all the extra dials? Yeah, I mean the Seiko 5. That Seiko 5 without the bezel. So if you want it without the bezel, then you get this one here or this one, right? So get this one, or here you go in solid black. How about that? That's classy as fuck. How about that? No external ring, just no rotating bezel. Just a nice, solid, kind of dressy watch, black on white, $230. What's not to love? What's not to love? So this is nice. You can kind of wear this with anything. This will look good with anything. It comes in other colors as well. You can get it here, $206 with a blue dial and a field watch style. Very, very cool. Get a used Rolex. A used Rolex is going to be a little bit more expensive than the price points we're talking about. A used Rolex is going to be a little bit more expensive. Do I think it'd be okay with a leather band? Sure. Yeah, no problem. Yeah, it looked great with a leather band. No problem. Yeah. So, yeah, I think they look great. So, yeah. And I think some of them come on a leather band. So, yeah, you can obviously replace the band. And the nice thing about the Seikos is they're moddable to hell. Like you can mod the ever-living shit out of Seikos. So you can absolutely, and like there's whole watch communities. So you can take something like this in black, and then you can absolutely change everything about it. You can change the bezel, you can change the hands, you can change everything, man. You can mod it to absolute shit if you're into that. So lots of cool options. Yeah, lots of cool options. The Seiko 5 is a great watch. It's a great choice. Seiko 5s are kind of lower line. Yes, they are. They're the lower line of Seiko, but a nice watch. Yeah, they're very, very nice. They're very well respected. Very well respected. Yeah. So, yeah. Or if you could also get the one that I have, this one's cool. If you, let's see, you can do something like, you could do something like, I'm just trying to find the right one. Well, I can't find exactly the one I was looking for, but you could do this one here. G-Shock multi-band 6, which is basically what I have here. That is solar powered, radio controlled. So that clock automatically sets itself every day using the atomic clock. And it's 6-band, which means it will set itself using the atomic clock in the US, Europe, China, Japan, and somewhere else as memory serves, because it can pick up the radio bands from all those places. $100. $100. It's a G-Shock. It will never, ever, ever die. It's solar. It's resistant to 200 feet of water resistance. It's the most accurate watch in the world. $100. Very cool. Very cool. No, you don't want digital? I totally understand that you don't want digital. I understand completely. So, but that's another option. All right. So anyways, going back to where we were in the story, we have discussed the lawsuit against Doge. We discussed that lawsuit against the buyout offer. Excuse me. Okay. And we can also discuss this, which is pretty just kind of petty. Trump says he's ending Biden's classified intelligence briefings. I mean, that's just kind of petty, right? That he's cutting off the ex-president's classified intelligence briefings. That's kind of petty, but hey, it's like one thing he can do. That's kind of interesting. Donald Trump said Friday he's revoking the president's access to government secrets and ending the daily intelligence briefings because Biden apparently did the same thing to him in 2021. So, I mean, Biden did it previously, so he's returning the petty. Does the Seiko 5 use quartz? No, it's mechanical. It's automatic. Trump announced his decision in a post on social media platforms shortly after he arrived at his Mar-a-Lago and private bat club. There's no need for Biden to continue receiving access. Therefore, we're revoking the clearance and stopping intelligence proceedings. He set this precedent in 2021. He instructed the intelligence community to stop me from accessing details as a courtesy provided to former presidents. Nice. So, hey, the vengeance works both ways. All right. I like talking watches. I've been in a watch kick lately. As some of you guys know, I've sort of been learning about watches or reinvigorating my love of watches. So I've been on a watch kick lately. I've worn this digital one like every day for like a year basically. And recently I decided to like break out some of my other watches and started wearing them again. So I'm on a watch kick right now. All right. Okay. Yeah, the Seiko 5 is very, very cool. You can't go wrong with the Seiko 5. And the watch community loves Seiko 5s. They love Seiko. Seiko is probably the watch community's favorite brand, and justifiably so. Seiko makes some really cool shit. And they're not very expensive, they're moddable, they're fun, they're reliable. They're great. Seiko's kick ass. And the Grand Seiko is beginning to really, appeal to me. I used to not really like the Grand Seiko, but it's beginning to appeal to me. But, I don't have $10,000 right now, so maybe later. All right. Anyways, in a different story, Leah Thomas's former teammates are suing UPenn and Harvard and NCAA to scrub the records. Nice. So to strip Leah of all those records that they never deserved in the first place because they're a fake and a phony. Grand Seiko is way better than a 5. Well, it is and it isn't. I mean, it's a lot nicer made. It's a lot more nicely polished. The spring drive is a lot more technologically interesting. But until very recently, I just haven't really liked Grand Seikos. So I mean, it depends a lot like what you like, right? There's no right answer to these questions, right? Well, it's just like going, what do you like? So Grand Seikos are more technologically, they're more refined, they're more polished. They're this spring drive is more technological, but you know, it's like at some level it's okay to say, but I like Seiko better, right? It's just like it's a preference thing, you know. Like there's some really expensive watches that I don't particularly care for, or I just don't think are worth it. Like, you know, like an AP or some Patek Philippe's, right? It's like I just don't think they're worth like $100,000. I just don't think they're really. Some of them look kind of shit to me, and I don't think they look like $100,000 watches. But you know, the market disagrees with me. You know, like the AP. It's just like, but you know, it's like it just doesn't. You know, I'd much rather buy a Rolex. Rolex only costs like 10,000, 15,000, depending on what you're trying to buy. If you can buy one, which is a whole other set of problems. But like you know, another one that really doesn't appeal to me is like Richard Mille. Those are really expensive watches. Those are like 6-figure watches, and it's like, it doesn't really do it for me. So, you know, just because it's more money doesn't necessarily mean that you like it. So it's okay to like watches that are cheaper. So is Grand Seiko better than Grand Seiko? It's like, oh, you know, it's a little bit like asking, is a Lexus better than Toyota? Like, well, it kind of depends on what you like to some degree, to be honest. You know? Anyways, 3 members of the University of Pennsylvania swimming team have taken action to expunge Leah Thomas's records because she is a phony. Yeah. You don't appreciate watches as art form more than spend a couple $100? Yeah, perfectly reasonable. There's lots of great watches that you can only get for a couple $100. So I totally appreciate that. That's fine by me. I get it. I completely get it. Grace Esterbrook, Ellen Holmquist, and Margot Kalswaki sued the University of Harvard and NCAA over the traumatizing experience sharing the team with Thomas. They accused the institutions of violating federal law by allowing Thomas to swim against the women and sharing locker room facilities. Thomas is not listed in the defendant as a lawsuit, which was filed one day before President Trump officially signed an executive order seeking to keep biological males out of women's sports. The complaint also seeks to create class action status on behalf of 206 female athletes who competed in the 2022 League Swimming and Diving Championships, which was hosted by Harvard. The lawsuit seeks to scrub the records from the Ivy League, NCAA, and Ivy institutions, including Harvard and UPenn, and receive a declaration that they were ineligible to complete. I hope that lawsuit works. I really hope that lawsuit works. I'm in for that. I'm in for that 100%. These women deserve their recognition, and Leah Thomas is a fraud. And I'm glad these lawsuits are coming, and they're coming a little late, but you know, the momentum has finally shifted, and go kick ass. Go kick ass. So we will probably follow that lawsuit. One of my mods make a notation, please, to see if we can find that lawsuit. I'm sure it was filed in federal court. We'll find that lawsuit and we'll cover that on a different stream because that sounds fun. Yeah. Of course, you could just be the most badass of all time and just get the ultimate watch. The Casio F91, $15. Worn by some of the greats. It keeps time. It's accurate. God tier. God tier. All right. We are going to end the stream with one last story, I think, because I don't think we have anything left. All right. So I have one more story left. All right. And for this story, you get to play along at home. Okay. We are going to talk about Florida Man. We're going to talk about Florida Man. And Florida Man has been charged with driving under the influence. I would like you, of course, to take note that the limit for driving under the influence is 0.08. 0.08 is the limit for DUI. Now, chat, what number do you think Florida man achieved? What number do you think Florida man achieved in his DUI? Taking note, the limit is 0.08. What number did Florida man achieve? I will let you contemplate that story as we read some of this. All right. The Haines Police Department arrested Miguel Angela Rodriguez, who is 43, on January 7th in Haines City of Polk County. Rodriguez currently sits in Polk County Jail, records show. A Haines City police officer was patrolling on January 7th when a concerned person called 911 about an unresponsive driver in the area of Davenport Boulevard, an arrest affidavit shows. The responding officer said that when he arrived at the scene, he saw Rodriguez unresponsive behind the wheel with his foot on the brake, the car in gear, and the engine running. Concerned for the safety of the driver and others, the officer said he positioned his patrol car in front of Rodriguez's vehicle to prevent it from lunging forward into traffic. Reports then show the officer attempted to wake Rodriguez, but was unsuccessful. The officer said he forced entry into passenger side window so he could put the vehicle in park and remove the keys from the ignition. Once inside the vehicle, the officer reported observing Rodriguez briefly opening his eyes, going in and out of consciousness, but apparently unaware of the events unfolding. Reports show the car had 12 opened and consumed bottles of wine. Reports show the car had 12 opened and consumed bottles of wine. Rodriguez was transported to the hospital, officials say, where tests confirmed dangerously high levels of alcohol. Officers released that Rodriguez does not have any prior DUI arrests, but does have a history of traffic citations. And finally, the moment of truth comes to us. Finally, the moment of truth comes. Police officers say Rodriguez was charged with one count of DUI, indicating a blood alcohol content of 0.523. 523. 5, 2, 3. Somehow, he's not dead. Somehow, he's not dead. Yeah. This incident underscores the seriousness of drunk driving under the influence. Haines City Police Chief said in a prepared statement, "We're grateful to the citizen who contacted law enforcement and no one was injured. We'll continue to work tirelessly to keep our roads safe from impaired drivers and will hold Rodriguez accountable." The officer said in his almost 30 years of law enforcement, more than 10 of those exclusively dedicated traffic homicide and DUI, Rodriguez's blood alcohol was the highest he ever remembers seeing, where the driver was still alive. And that brings us to the end of that story. I mean, anything 0.4 or greater, you are entering danger zone for death, for sure. Right? I mean, if you're 0.4 or more, you are really flirting with death. And this guy is 0.523. This guy is a winner. This guy is a winner. So, yeah. So I think we're probably done with the stream. And I had fun, and I hope you had fun. We had a good time. And Runkle the Bailey is streaming, so I will send you over his way because we like Runkle. So let me just set up a second, and I will set you his way. Yeah. for the 200 of you who spent some time with me. And I do appreciate you spending some time with me. We had fun. We had fun and we lost our mind at that one judge. So, yeah. We lost our mind at that one judge. So we'll go ahead and sign off. And thank you very much for your super chats, as always, and for your participation. It is always appreciated. Am I doing it regularly now? What? Friday nights? No. Typically, this is Rob's time. Rob just wasn't streaming today, so I decided to do a stream. I mean, I don't go out of my way. Like, if I had something important to stream about, I'd stream, but this is just like a fun, this is just a fun Friday casual show. So, like, this is just a fun, like, you know, variety show. So if I had something important to stream about, I'd stream on Friday. But like doing the fun variety show thing is kind of Rob's thing. But Rob wasn't streaming today, so I decided to stream because, you know, Rob wasn't streaming. And I thought it might be fun. I thought some people might want to hang out with me and see it, and I'd have a good time. So, you know, and I'm streaming all the time. I stream, you know, throughout the day, as I'm sure many of you know. So I stream constantly. So yeah. What are my serious shows like? Well, you can check them out. I've got lots of shows on my channel. You should check one of them out. They're fun. You should check. I got like 3,000 videos on my channel. Check them out. They're good times. All right. I've been on Civil Law. Until later, my friends. I hope all's well for now. Cheers, my friends, for now. And goodbye.